Good morning and welcome back to Eyewitness News here on the KSCW Legal Counsel. Charlie O'Hara joining us once again on this Wednesday morning. Good morning, Charlie, and congrats on the new grandbaby.
Thank you. We're really excited.
Well, I'm glad everyone is happy and healthy, and we're glad to have you here.
Yes, I'm glad to be here.
We do have a few phone calls on the line. We'll go ahead and get to those. Good morning. What's your question for Charlie?
Yeah, hi.
Hi there.
Hi. I have a question about a DUI I recently received. It's my third one, and my question is on my second one, I was charged with a DUI, but I was only found guilty of an open container, and I was wondering if that would affect the stacking process.
Well, I think what you're referring to as stacking is the first time you have a DUI, it's a misdemeanor with a certain penalty. The second conviction, if you're convicted, would be a more severe penalty, but still a misdemeanor. The third conviction is actually a felony, and as you get more of them, the punishments become more severe. Still, the most you can get on any DUI is 1 year. But you have to be convicted. The fact that you're charged with something and acquitted of that, or it's a different charge like open container, that doesn't count. You actually have to be convicted of a DUI.
Okay.
So if he wasn't convicted of a DUI, that would not count as far as enhancing the penalty. But the more you get, the more enhanced it gets, and you can do a full year on a DUI. Wow. And on some of them, the judge doesn't have much discretion. He has to keep you in jail maybe 90 days, and the more you get, the longer the judge is inclined to keep you in jail. So if you have 4 or 5, you may be in jail quite a while.
Okay, thank you, Charlie. We're going to head back to the phones. Another caller on the line. Good morning. What's your question for Charlie?
Hi. My husband and I, when we got together, he had a previous child by another woman, and he was ordered to pay child support. Now, he's been trying to get in this child's life, and we got gifts throughout the years for this child, but her mother won't let us see her. Basically, she just wants the money, and we feel as if, you know, it's more to support a child than just by money, and we try to get help from the Kansas legal aid, and they still want like $800 as far as visitations and all that. And I was wondering, what else could we do so we could see this child, even though we're paying for it?
Well, most people don't understand this, but paying child support is separate from visitation. And even if you don't have the money to pay child support, you're still entitled to visitation. If you do pay the child support, sometimes you're not entitled to visitation. They're totally separate issues. So the fact that you're paying child support doesn't guarantee you get visitation. However, if the only way to really enforce something like that, if someone's not following a court order, is to go to court. And you have to have an attorney. Usually you can represent yourself, but you're usually better off with an attorney. You should hire an attorney, is what I would recommend. If you have enough money to pay the child support, probably you can scrape enough money to either get like you say, somebody to do it for $800 or maybe somebody more. But if you can't do that, you can always represent yourself. But you need to go to court to enforce that visitation.
Well, and I know we've had several calls like this in the past where it seems like if you pay child support, you'd get to see your child, but like you said, that's not always the case.
Well, they're totally separate issues, and that's what people don't realize. One doesn't mean you get the other. I mean, you can not pay your child support ever and still have visitation.
But either way,
or vice versa.
You're going to need an attorney for this one.
Well, you can do it yourself, but I always think in something like that, you're better off with an attorney.
Okay, thank you, Charlie. Good to have you back.
Thanks.
Thanks so much.